What he did for those 20 hours is hocus pocus, and he makes an exhibit that is out of focus. What the state is relying. Mr. Bigger says it's impossible for him to have threatened my client. That's garbage, just like his case. Did you hear that? Talking about a pepper ball exploding in her ass. That's Kelly Zeminski speaking. This case is not a game. It is my client's life. We don't play fast and loose with the facts, pretending that Mr. Rosenbaum was Citizen A #1 guy. He was a bad man. He was there. He was causing trouble. He was a rioter. And my client had to deal with him that night alone. When I say that the truth matters and this is not a game, what do I mean by that? Mr. Binger is the one who put on the Kandari brothers. The reason he put them on, in spite of what he might say today, is because he wanted you, now 18, soon to be 12 people, to say, gosh, that kid just went to that place and just protected it. He wasn't asked. He was asked. Mr. Kandari's asked Nick. Nick got a group of people to go down there. The people from West Bend came. Provocation, another thing. With an AR-15, and you don't say boo, correct?
I didn't say anything, correct?
And you have the ability to speak.
Yes.
If you wanted to object, you could have said something to Kyle, correct?
Yes, I could have.
And you didn't.
No.
Because you wanted him to have the gun for protection.
Not that reason exactly.
You wanted a gun for protection.
Yes.
Within a few feet of all this stuff going on. So it is a perfectly reasonable understanding that he is witnessing this and that this is forming his state of mind. He is seeing confrontations. We are showing the jury those confrontations. These are occurring right in front of his face. So this is him right there. I'm not showing stuff that was 10 blocks away. I'm showing what was right in front of him as he's witnessing. We've already seen him in this video. Now, if the defense wants to argue he didn't witness it, if they've got evidence to suggest that, they can argue that in the jury.
I guess what the state is getting at is the injuries weren't serious, so he shouldn't have shot. Fair?
Fair.
Okay. When you're being kicked in the head, you don't know what's going to happen to you. Is that a fair statement?
Fair.
Okay. When somebody's hitting you in the back of the head the second time with a skateboard, you don't know what's happening to you, correct?
Correct.
When somebody puts their bare hand on your firearm, trying to take it away from your person, you don't know whether or not that person is going to get your gun and turn it and use it on you, correct?
You don't know. No. Correct.
And it's a general training principle. You don't give up your gun because it's a deadly and dangerous weapon, correct?
I'm going to object to this line here. This is not an expert witness, and that this last question is about training for police officers, which is not relevant.
Rephrase your question.
Sir, if a weapon is taken from somebody, it can be used against them as a deadly and dangerous weapon, correct?
Correct.
Based upon your investigation, who is that?
That appears to be Mr. Rittenhouse.
Okay. And that's when he's being chased by Mr. Rosenbaum.
I don't know if it's right before the chase, but approximately the start of the chase time is when that audio appears to come out.
Okay. And that would be something to say to someone, I don't have a beef with you, friendly.
Yes.
And that didn't dissuade Mr. Rosenbaum, based upon your investigation and viewing of the videos, from continue to attempt to attack my client, correct?
Correct.
And as my client is running from Mr. Rosenbaum, is he gaining ground on Mr. Rosenbaum, or is Mr. Rosenbaum gaining ground on him?
Looks like Mr. Rosenbaum is gradually gaining ground on Mr. Rittenhouse.
And Mr. Rosenbaum is running towards my client, and my client turns around and points the gun in his direction. Does not level it at him, but makes it very clear that he's armed to Mr. Rosenbaum, correct?
Correct.
And Mr. Rosenbaum is not dissuaded by that firearm and continues to chase after my client.
He stops briefly and then continues to run again.
He doesn't stop like I'm standing here and say, contemplating life's realities, like maybe I should pick a better course of action. He slows his gait and then continues on after Kyle, correct?
Correct.
But came at him with the skateboard and grabbed the weapon. They are calling him the first aggressor, although now they're apparently not. So we can rebut.
Thinking, as he said before chasing him, you won't do shit, MFer, to my client. Well, he was wrong. But the little guy who gets beat up likes to go after the next littlest guy. He saw Kyle alone, and that's what he chose to. Or he could have been mistaken and thinking it was the other person at the ultimate that he went after and had to be held back. They were dressed very similarly, baseball caps, mask, and the only difference was the difference between shorts and a long pants. I can't answer that. Mr. Rosenbaum at this point, I guess, can't either. He didn't have a valid concealed carry permit. He wasn't charged. He lies to the police about being armed that night. He said he dropped his gun going down the street. Ladies and gentlemen, that's what's called obstructing. Most people, when you lie to the cops, especially in a murder investigation, you get in a little bit of trouble. I've represented some of those people. Not Mr. Groskwitz, because he's their star witness. Bought, paid for, and protected. You don't want us to search your phone? Oh, we're going to invoke the never heard before Marcy's Law exception to the search warrant, even though they had a signed search warrant by a judge of Kenosha County. He was also an armed medic. Wants you to believe that he didn't have one in the chamber and he would never shoot somebody. But before he said that, he said, key, wallet, phone, gun. He never leaves the home without them. Ladies and gentlemen, I don't carry a concealed weapon. And I don't think I could shoot somebody. But when people carry guns, that's what they're for in the city. This isn't the Wild Wild West. He had his gun. Kyle Rittenhouse had run by him. You'll see the picture. Was by him, gone. Did he go to give medical help? He didn't know that Mr. Rosenbaum was being tended to. No, he decided to run in and advance on the fray. He, affiliated with the American People's Revolution here in Wisconsin. And I might have that one word wrong, but he did it. And who ultimately put the tourniquet and fixed it on his arm? But Mr. Lukowski, a member of somebody he refers to as the militia and the Stooges. Two different encounters between Gage Groskwitz and my client. The first one, he does not show or give any indication of a weapon. My client does not point a weapon at him, does not shoot at him, does not swipe the weapon towards him. He states he's going to the police. That is uncontradicted. Why doesn't Mr. Groskwitz let him be and go give aid and comfort to his fellow rioter? But instead, he joins the mob, chasing Kyle, arms himself, and runs in the fifth or sixth person into the melee in scene 2. And when his friend was called, his friend said in his Facebook post, his only regret was not emptying the clip into the kid. So we know what his intent was. We know what he wanted to do. Kyle shot first as he was coming in. And Mr. Binger talks about, oh, he was going to grab the gun. Ladies and gentlemen, left hand, phone. How's he going to grab a gun with a hand filled with a phone? Right hand, gun. He goes back, loads up, and is advancing. That's when Kyle shoots him. He didn't shoot him when he put his hands up, and if that was it, no intent to harm him. All he does, like everybody else, is back up, and nobody else gets shot. But Mr. Groskowitz decides he's going to shoot my client. Unfortunately, my client shot him first. Ladies and gentlemen, that's the case. There was no threatening behavior that started this. Mr. Rosenbaum was hell-bent on causing trouble that night. He did what he did, and he started this. There are tragic parts of it, but Kyle Rittenhouse's behavior was under the law of the state of Wisconsin. You've heard the instructions, and I'll end with this. You decide on count one. If you decide that his conduct was privileged under the use of self-defense, you don't go on to the lesser included. If it was privileged under self-defense, that affects count two. Both of the things that happened in scene one, as I read earlier, page 9 of the jury instructions. If his conduct was privileged as to Rosenbaum, it's privileged as to Mr. McGinnis. On to the next ones. At scene 2, ladies and gentlemen, there is no evidence whatsoever that he was an active shooter other than Mr. Binger calling him that. And there's no evidence that any of those other individuals who attacked him in the mob that night were attacking an active shooter. He wasn't shooting. And if they want to be the heroes and they want to beat somebody and do what they're going to do to them, they better be right. And they weren't. Kyle Rittenhouse shot Mr. Rosenbaum because he was attacking Kyle. Every person who was shot was attacking Kyle. One with a skateboard, one with his hands, one with his feet, one with a gun. Hands and feet can cause great bodily harm. I'm sure the state's going to get up and say, well, he didn't have great bodily harm, so it doesn't matter. That's not the standard. The standard is could cause great bodily harm. My client does not have to take a beating from the hands of this mob or the hands of Mr. Rosenbaum. And Mr. Rosenbaum might be little, but he is a pretty muscular guy. And some 30-some-year-old guy can take a 17-year-old kid 9 times till Tuesday. Ladies and gentlemen, it's a tough choice, but the evidence only leads to one conclusion. That is that Kyle Rittenhouse's conduct on August 25th was privileged based upon the actions of Mr. Rosenbaum and others. There are no winners in this case, but putting Kyle Rittenhouse down for something he was privileged to do will serve no legitimate purpose. I ask you to do this, do justice here under the law of the state of Wisconsin. Thank you very much.
Wisconsin used the word vigilante to refer to your client since the verdict came down. How do you react to that?
Maybe they should have watched the trial.